Hi, I'm Chip Rogers, and welcome to the AAHOA Educational Experience. This week we are talking about immigration, employment, and enforcement. And joining me on the panel of experts this week, we start with Michael Patrick, who is a partner at Fragaman, Delray, Bernson, and Lowy. And next to him is Patrick Shen, who is the Director of Global Compliance, also with Fragaman, Delray, Bernson, and Lowy. And finally, Jacqueline Wolf, who is a partner at Manat, Phelps & Phillips, also co-chair of Corporate Investigations and White Collar Defense. Thank you all three for being with us today.
Pleasure. Thank you, Chip.
In previous shows, we've talked about E-Verify, we've talked about the responsibilities of the employer, even as muddy as that may be. But all of this, of course, stems from somebody somewhere making a law. I know a lot of times I'll talk to kids in classrooms about how a bill becomes a law. And it all starts with an idea. Somebody has a grand idea. Well, back in 1986, the issue of illegal immigration wasn't quite what it is today, but you had pockets of problems in California and other places, and the federal government came up with a federal law. In 1996, they did it again, and in between, they've made some changes, and now, of course, the states are getting into the mix. But here we are in 2011, and I don't know that the issue is going away. It'll certainly be part of the 2012 campaign. And as we talk, Congress is again looking at the issue of immigration law. What's being considered, and what's the likelihood that anything will ever get done?
Well, it is, as you just pointed out, Chip, a hot potato issue, which means it's hard for anyone to get involved in the dialogue without the risk of alienating or even offending certain voters. The Obama administration is on record saying we want comprehensive immigration reform, but most people are not seeing leadership. The political pundits are saying because they don't want to lead on that, because they're going to get hit from not just two sides, but three or four sides. People in Congress are now saying we need some immigration reform, but the only serious player at the moment appears to be enforcement oriented. And many people have said we have to have both enforcement, but we also have to have smarter and better immigration rules. And what about the 11 million people that are in America that are not here in status? The notion that we're going to put them all on buses and trains and deport them is ridiculous. So we need to have a plan. To which others say, but didn't we give amnesty back in 1986? And why would we do it again? And the answer has to be because we'll have to have a better system that will say, we'll do it one more time, and from then on, it's going to work better. That better system is not fully in place yet.
Doesn't sound like it. Patrick, I want to follow up on that a little bit. I know that the Republicans took over in the House of Representatives. And that, of course, is a major change from the Pelosi-led House, which was probably not real keen on enforcement. And one of the first major bills we're seeing come out of this Congress dealing with this particular issue is a bill that would require mandatory universal use of E-Verify. Explain that to us.
Sure. This is actually a part of immigration discussion over better part of the last decade, starting with President Bush. Who laid out his vision for comprehensive immigration reform, which, by the way, looks remarkably similar to President Obama's vision for comprehensive immigration reform. And both presidents, despite their best intentions and good efforts, failed. So the only thing there seems to be agreement on, certainly at least among the House Republicans, is to enhance the enforcement side first. So Chairman Lamar Smith from Texas, who was the chairman of the House Judiciary Committee, introduced the Legal Workers Act. And what that bill would do, in a nutshell, is not only mandate the E-Verify usage, but to significantly increase penalties for violations as well, and criminal and civil penalties. And in addition to that, it would standardize a set of federal enforcement requirements and preempt the states from having their individual laws going forward.
And that, of course, is a big issue at the state level. Because states are saying, well, you can pass what you want, but why are you telling us what we can pass and can't pass? I know states get very upset when that happens on all matters of law. I want to talk about the need, though, for some sort of uniformity in this area, because I think we talked earlier that perhaps you have an employer who is they're doing E-Verify, and the guy across the street's not doing E-Verify. Is that really a workable system, or is that a fair system? Is that a level playing field? Jacqueline?
Well, it's probably not a level playing field, because to start with, if you're in E-Verify, you obviously are not getting all the workers and all the applicants coming in. The other problem with E-Verify that we've seen is that you've got workers who might have worked there, might have applied there in the past with completely fake counterfeit documentation. It might look good on its face, but it wasn't hurting anybody. In other words, arguably it was a victimless crime. You'd come in, you'd have your fake documentation. It looked okay to the employer. The employer did not know that you were not authorized to work and you got employed. Now you have a situation where if you are an E-Verify employer, an employee who's not authorized knows they have to get something that's going to get them through E-Verify. And the only thing that's going to get them through E-Verify so they can get a job is going to be stealing someone else's identity. And that is already not good for an employer. An employer does not want to have a whole bunch of people stealing the identity of other people. To begin with, you're going to get a lot of phone calls from SSA, from the IRS, and probably from the person who sees income on their statement that they didn't earn. So it creates a whole hornet's nest, really, for the employer. And ultimately, you end up having to terminate these people as soon as the IRS shows up at your doorstep and says, this is the wrong person, this isn't who you said or who they said they are. You then lose your workforce. So being on E-Verify has so many negative things that can happen to that employer who wants to be compliant that it's really not a good situation. And I think the other thing is that you're going to see employees that then get terminated because somebody starts to implement E-Verify. And I believe this new law would be a little different also because now you can't go retroactively back and use E-Verify in your current employees unless you're a federal contractor, I believe. But in this new law, you could do it sort of as an applicant comes in. You would be using E-Verify. I believe that's the case, Pat.
I think that is a critical point because just to draw that distinction, under current law for E-Verify, you sign up with the government memorandum of understanding. You can't use it to screen an applicant. You can only do it after that person's been hired. You have to do it, I believe, within 3 days. And you can only do it for that individual that's hired, and you can't do it for anyone who was hired prior to the date that you joined E-Verify. This would change the nature of that completely.
Actually, what this bill, what the Chairman Smith's proposal would do is to leave that to the discretion of the employer. So the employer would have the discretion to use it on the existing workforce. And the reason that discretion is there, I think makes sense, is that there are some industries that don't have a problem with prevalent illegal or unauthorized employment. And they tend to be very large multinational corporations that may not have the incentive to check on a workforce that they know is legal. Whereas there are other industries that may want to do that to once and for all clean up the workforce and to reduce liability. So the bill actually leaves it voluntary.
But it would be all or nothing at all.
That's right. That's why, yeah. Well, the bill,
Right.
Chairman Smith, I guess, does not want to encourage selective enforcement, which then, of course, may, rightly or wrongly, cause employers to be accused of discriminatory selective enforcement.
But Michael, you touched on this. You referenced in an earlier show the enforcement by the current administration is more than just about all the other administrations combined. But this is a political issue that seems to now raise its head every 2 years, and clearly every 4 years during a presidential election. Are we at a point in time where the bill being offered in the House is something that the president might go along with, just to say he's actually done something on immigration?
I would suggest that if Chairman Smith's bill gets up steam and gets going, the Democrats and the president will not be able to afford not supporting it. Right before a presidential election year. It's about enforcement. It's about protecting jobs for U.S. workers. In a down economy, it's going to be very difficult politically to stand up and say, I'm not going to support this unless you agree to legalize 11 million illegal workers.
Yeah, and I don't think we're going to see that. Not, of course, the polls would not indicate that answer is coming. In the next segment, we want to talk about some of the issues that are happening at the state level because, as you pointed out with Chairman Smith's bill, one point in that bill that has a lot of states concerned is that this would be the federal government saying, okay, we're taking over. And I know from a legal standpoint, that is what has been argued. Do the states even have the authority to operate in this arena? And I believe the Supreme Court recently said that they do. I think the feds may be on the verge of saying, you don't have the authority, we're going to take the full authority. But we'll have to do that in the next segment. So we'll talk about that and a lot more coming up right after this. Welcome back. I'm Chip Rogers, and you're watching the AAHOA Educational Experience. This week we are talking about employment, immigration, and enforcement. Before the break, we discussed how the federal government is again revisiting this issue, and you may have the political winds blowing in a manner that could actually produce another major change, first one we've had in quite some time. But in addition to the federal government, some of the pent-up frustration, particularly in border states or states that have been impacted by illegal immigration, has resulted in a number of individual states addressing immigration. Michael, I want to talk about that from an employer perspective. I would suspect 10 years ago, as an employer, your concern was, well, I don't want the federal government to come knocking on my door. Now you have to worry about the federal government knocking on your door, the state X knocking on your door, or city X knocking on your door. It is a multi-layered enforcement approach now.
Well, it is because the states have always had the ability to pass rules and requirements for businesses, for employers, on a state level, not a federal level. They just didn't put immigration into the mix until the last decade. And now they've realized that they can put it in the mix in a big way. The Supreme Court has said if it has to do with licensing, it's perfectly okay because Congress created the exception that says if the states want to have laws on licensing that involve immigration, that's okay. So what we have now are employers needing to look over their left shoulder to see whether the federal government might be knocking on the door regarding federal obligations, then their right shoulder to see whether the state or the local government is coming after them. And there have been local prosecutions. There's no question that the politicians at the state level believe that they are being supported by their constituency when they are going after employers who they think are employing people without authorization. And the polls seem to indicate that America says we're sick and tired of an immigration system that doesn't adequately prevent the hiring of workers who don't have authorization.
And this is something that the U.S. Supreme Court recently waded into with the decision on E-Verify from the state of Arizona.
That's correct, Chip. The Supreme Court decided recently that the licensing exception that Michael mentioned was wide enough to allow the state law, to allow a law such as the Arizona statute, which imposes the state's own set of E-Verify requirements. The Chamber of Commerce argument was that, I mean, you can't argue with what's written in plain language in the immigration statute, but the Chamber of Commerce argued that what the licensing exception meant was the state can say, we want you as an employer to follow federal immigration law or else we don't want to do business with you. But that states cannot say, well, by the way, we have our own set of immigration laws we want to impose as well. And of course, Arizona argued that the exception did apply to even state laws, and the Supreme Court ultimately agreed with the state of Arizona.
Jacqueline, what does this mean for an employer who has business interests in multiple states?
Well, I think it makes it unworkable. I really do. I mean, it's.
I agree.
If you're, and many companies have a manufacturing plant in one state, you'll have the sales and marketing in another state, and I don't think you can function that way if you have to worry about how you hire people in different areas. The other thing is, we've seen in a different context the memorandums of agreement and understanding between the states and the feds on the ability of the local law enforcement to conduct arrests of supposedly potentially illegal aliens. And to assist ICE in tracking down and arresting people. That hasn't turned out particularly well, in that there's been a lot of arrests that have been, discrimination, and there are people that are being arrested because of their race, not because of them being unauthorized to work. In fact, they very often could be citizens. So because when you get to the local level, there's so many personal, emotional reactions to immigration, and people have such strong feelings, it's slightly dangerous to go into that area. And I think, in terms of what we've seen, that having the states or the local folks enforce these laws could be a big problem, because there's going to be sort of I think the discrimination issues are actually fairly great there.
Well, the notion that someone says, I can tell an illegal alien when I see one, that type of attitude takes us in what I think an un-American direction. Because that's about saying, oh, because that person looks like they're fill in the blank, Hispanic. They look like they're Asian. They clearly might be illegal. We have to ask them questions differently than we would ask someone who looks like they aren't. It's too subjective.
I agree. I definitely agree. And I think what's going to happen, if you really do have a patchwork of different laws in different states, you're going to have people taking whatever prejudices they have, and they'll be applying them. You're going to have people applying prejudices that, if it's a federal system, it's less likely to occur, I think.
Well, the law enforcement side is something different, but it certainly impacts the employment side. I mean, there's no way you can extricate those two away from each other. But through the years, the federal government has come up with visa program after visa program after visa program. I think I once read there's 19 or 20 actual different visa programs, maybe more. But the ones people hear about, the H-1B, the H-2A, do these work? And if not, why aren't they working?
Oh, I think there's a fairly widespread acceptance among both scholars and legislators and just people who practice in immigration that the current system for both what we'll call temporary workers or non-immigrant visas, as well as permanent workers, which means green card sponsorship, is not where it needs to be if your goal is what's in the best interests of America. We have employers at many, many levels saying, I can't get enough workers, but we have high unemployment. What's the problem? Well, some people say because the employers aren't paying enough salary, the wages are too low, but statistics will show that a lot of those employers are paying at least minimum wage and sometimes more. So there's a concern that America's system is too restrictive and not allowing in enough of the kinds of workers at all levels, both the lesser skilled and then the higher skilled level. Then you have the whole issue of trying to get green cards and residence where the waiting lines today are so long in the employer sponsorship world. We only allow 140,000 green cards a year, and that includes spouses and children of the principal being sponsored. 140,000. So you're talking about, in terms of principals, 60, 70, 80,000 max a year. That's it. So America's system is not serving the interests of America, and many, many people have agreed to that. The problem is, in economic times where people are out of work and there's concern about employment, it's hard to advocate opening the door wider to let non-Americans in. Counter that with the argument that those people many times, particularly at the higher skill level, help create jobs, even start new companies.
Patrick, if you're an employer and you're in one of those areas, even with high unemployment, there are some areas where you are having a difficult time getting workers. I know in my home state we have a large jet manufacturer there who does very highly specific technical work, and they can't get all the workers. What do you do as an employer? If you can't find the specific type of workforce you absolutely need, how can you rely on the federal government? How can they help you?
Well, I mean, that's the question that I think Congress has been trying to answer. Unfortunately, they can't come to a consensus on what that answer is. I mean, what we don't want to do is have a scenario which we're sort of getting there already, unfortunately, where employers want to do business here because American executives want to raise their families in this country. We have I would imagine one of the best, if not the best. We're immigration lawyers, but we've heard that we have one of the best intellectual property protections around the world. So there are a lot of reasons to want to do business here, but the bottom line is if you can't get the right talent to do the right job at the right time, then the employers may have no other choice but to succumb to our competitors, other countries who are vying for the same workers.
But Patrick, wouldn't you agree, though, that in the area of science, technology, engineering, and math, the acronym known as STEM, that Congress has started to wake up to the argument that Bill Gates, for example, at Microsoft has been talking about for over 10 years, the argument that America has to get smarter here to attract the best and the brightest from around the world, particularly those that we educate at our own schools and universities to PhD programs, has to get smarter with a policy that incents these people to be able to stay here and allows employers to employ them here.
Sure, and it's not, STEM is a big part of it, and business schools too. I mean, if you look at the top MBA programs, about 40% of the graduates are foreign students. So definitely, in STEM and business. But Michael, what's happening though is that while there is a growing recognition and thus growing attention, thus drawing a lot of attention on this issue, it's also drawing a lot of opposition as well. And we expect that in the lawmaking process. The more you talk about something, the more the opposition, in this case, those who want to protect the domestic workforce, notwithstanding our skill shortage. So there's a lot of opposition there as well. In the last couple of years, we have not seen any bills from Congress that became law that would help alleviate the skills shortage. We have, however, seen several bills that restrict the access even further.
But in addition to Chairman Smith's bill on enforcement right now, there are some proposals, we don't know whether they'll go anywhere, that actually are trying to alleviate some of that pressure and allow more skilled immigration into the United States.
Well, they are. For example, the bill called the Skill Act that Senator John Cornyn has introduced several times. It never went anywhere, but he introduced it several times. He may do it again.
Persistence is the key in passing legislation.
At some point, yeah.
We are flat out of time, but I really thank you for being with us today. Jacqueline Wolf, thank you so much,
Thank you.
and Patrick Shen and Michael Patrick. This
Pleasure.
has been a great time, and I hope you enjoyed it. If you have any questions, you can reach me, chip@AAHOA.com. That's chip@AAHOA.com. Thank you so much for watching, and we will see you again next week.